What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hello everyone, I'm Chris Wilson, and today I'll be hosting the first in a series of podcasts in the ABA's Trust and Trade series. We're really excited to be a part of this effort, especially during such a dynamic time for antitrust and consumer protection. Even just this past Friday, the White House released an executive order touching on numerous aspects of competition and consumer protection issues in a range of industries. On today's podcast, we'll be talking about the FTC's ability to obtain money damages in the wake of AMG Capital Management versus FTC. But first, let's start off with introductions. I'm Chris, and I'm an Counsel at Gibson, Dunn, and I specialize in antitrust and consumer protection issues. I started my career at Gibson and spent several years as a trial attorney in DOJ's antitrust division, where I investigated or prosecuted violations of the antitrust laws, including proposed mergers, before coming back to Gibson in 2018. Rich Cunningham is a partner at Kirkland Ellis, and he specializes in antitrust and consumer protection matters. Rich spent the first 9 years of his career at the FTC, and while there was a member of multiple FTC trial teams during the 2000s and early 2010s. And in full disclosure, Rich and I worked together several job changes ago. A quick note at the outset. Rich and I have both represented and are representing clients that are involved in ongoing FTC investigations and litigations, and are not speaking today on behalf of any client or on behalf of our firms. Rather, our thoughts and comments are solely our own. I'd first like to orient around the content of the article. The title is A Watershed Moment, What Comes Next for the FTC in the Wake of AMG? Rich, would you mind giving us a short synopsis of the ground you and your co-authors cover?
Absolutely. First, thanks so much for doing this today, Chris. Really appreciate the opportunity to collaborate with you on this, and also I'm really grateful to the ABA for the opportunity to put this article into the next issue of the magazine that's coming out soon. The title may strike people as a little bit overblown. Watershed Moment, is that really a fair description? And I think it is. Unlike a lot of legal issues, this one really has a narrative arc, and there really is a moment in time occurring that we're all living through that's going to be a meaningful change in how the FTC carries out its mandate to enforce the antitrust and consumer protection laws. So let's flash back a little bit. If you go back to the 1970s, the FTC staff lawyers and leadership of the agency really got creative in going after fraud. They looked at their statutory authority and they said, geez, doing a ALJ administrative litigation, taking it all the way through, obtaining a ruling of liability against the defendant, and having that hold up on appeal, and then initiating another federal action under Section 19 to obtain money is a lengthy process. And more importantly, I think from the people that were involved in those days, it gave the target ample time to get rid of the money, to move it overseas, to buy things, etc. And often there was nothing left, really even a matter of months into the matter proceeding. So the FTC lawyers saw this happening and realized that they needed stronger tools up front to push into the fraud and preserve the possibility of obtaining some money for victims. This started with the idea of an asset freeze, a logical form of injunction that the FTC would obtain out of the gate. And it is sensible that if the federal court is going to freeze assets, that it, after a finding of liability, would have the ability to authorize the agency to disperse those assets to the victims. And that line of thinking about what kind of process would be sensible in those cases and efficient in those cases led to a very creative reading of Section 13B of the FTC Act, where the word injunction was read to by the Commission and advocated successfully for many, many years to include the ordering of the payment of money by the defendant in the form of disgorgement or restitution. These are traditional equitable monetary remedies that can be traced quite a ways back in the law, but are candidly somewhat different than an injunction, at least as that term is usually understood by lawyers in courts. But I think the combination of a compelling need for this authority in fraud cases, these are situations where there's just clear consumer fraud going on, and a current in the courts to read statutory authority broadly led the FTC to have tremendous success with this approach and this argument over time. The Seventh Circuit started the trend of blessing this approval in the 1980s, and at one point, I believe it was 8 or 9 separate federal circuit courts had endorsed this process over the course of 30 years, and it became the FTC's go-to way to obtain money. It became the absolute standard in both antitrust cases and consumer protection cases to use this authority in all circumstances, whether it's a true hardcore fraud practice or whether it was a much more nuanced matter involving advertising substantiation or disclosure issues or antitrust theories around monopolization. The FTC's go-to mechanism was to use 13B to get money. It was faster, more efficient, lower standards of proof that are under that exist under Section 19, and really no downside for the agency. So it became the go-to method. Well, starting about 4 or 5 years ago, then this is after a very long period of defendants complaining about the process and filing various motions and various arguments to try to eliminate this authority or curtail it in their matter or circumscribe it in some way. The courts began to take another look at this issue. It started in the Ninth Circuit in a concurrence. It then was addressed by the Seventh Circuit in a case called Credit Bureau a couple of years ago, where the Seventh Circuit looked at its prior approach and said, no, this isn't right, and felt that the commission had the commission reading of 13B was incorrect. And I think a couple of things are going on here. One is that because this strategy became the commission's default, it was using it in all sorts of cases, not simply hardcore fraud cases. The questions around it gained a lot more traction. We're not talking about pure fraudsters in all cases. The second and probably more important factor is the turning of the tide in the way the Supreme Court is reading statutes in terms of how much authority they provide agencies. There's a fairly clear turn in the Supreme Court's approach to statutory interpretation that started 5 or 6 or 8 years ago, perhaps even a little bit earlier than that. And the case that we're talking about, the AMG matter, where the word injunction is read more narrowly, not include money in 13B, is really another decision in a fairly long line of cases at this point where the Supreme Court is saying, no, we're going to read the words Congress wrote more narrowly. We're not going to imply powers for the agencies. So you've got this fascinating narrative arc where the FTC takes an aggressive, creative legal position, has great success with it, and then the tide turns. And at this point, in the AMG decision that came out in March, the agency lost its authority to obtain money under 13B. And then the question is, well, what's next? And I think it's unclear. There's 2 basic possibilities. One is that the agency receives new legislation, and there is a meaningful movement afoot to give the FTC more powers in this space in Congress. And the other possibility is the agency pivots back to other tools, rule enforcement, order enforcement, and of course Section 19 in cases where money is warranted. And that, to me, either path is something of a watershed. We're going from a world that was very 13B centric, where the action was in federal court, to a world where the FTC is going to be using different tools of some sort, whether it's new legislation or the current tools. I'm very confident that the FTC is not going to stop enforcing its mandate. Rather, it will be creative. It will find ways, either with existing authority or with new authority, to continue the agency's work.
me a little bit about your co-authors, Sean Royal and Olivia Adendorf. Who are they, and how did it work for you to come together to write with them?
Yeah, great question, Chris. So Sean and Olivia are colleagues. We're all at Kirkland. We work together in various combinations on matters before the FTC, both consumer protection and antitrust. We are also good friends and enjoy, talking about these issues, sharing our experiences with them, and frankly, trying to contribute to the discussion in our community around what's going on in antitrust and consumer protection law. Sean, like me, was at the agency for some period of time in the early 2000s. He really has had a front row seat. Those are words that he wrote in our article to this narrative arc and this change. Olivia is more of a contemporary of mine in terms of seniority, but again spends a very large portion of her practice on these issues and has litigated them both in court and then litigated isn't the right word, but I know you know from your time at DOJ that hashing these issues out with staff can be as important to the impact of the outcome of a matter as anything else.
So why is the AMG decision so impactful for the FTC?
I think what really matters is that it requires a different approach. It's going to require a different playbook for the FTC, either under existing authority or if they get new legislation, unless the legislation is so similar to the path in 13B that it really doesn't impose new changes. But I think the more likely thing is that there will be, even if there's new legislation, some differences, whether it's the standard of proof or statute of limitations, what have you. All those issues remain to be hashed out. But we are going to see a different playbook from the Commission for the first time in a long time, especially on the consumer protection side of the house. And that's quite fascinating for all involved. The FTC only has one administrative law judge, Judge Chappell. He, despite having a really impressive work ethic and level of bandwidth, there are limits to what he can do. So there's practical considerations if the FTC pivots to an administrative strategy primarily. Another strategy that we talk a little bit about in the article would be more collaboration with states and other regulators. That is going to spur the agency to build new bonds and collaborate in ways it never has before. I think that will change how we see complaints styled and the dynamics that exist in investigations and litigation. So I think what's impactful about it is going to mean change for those of us that practice before the agency and certainly for the agency lawyers. And that's pretty remarkable. The FTC comes up in front of the Supreme Court every few years, and almost without exception, it matters and has an impact on how the FTC does business. But unlike past Supreme Court cases that have been pretty subject matter specific, AMG deals with the core statutory framework of the agency's operation, especially on the consumer protection side. So it's going to, and I think it's fair to say already has, result in some meaningful changes.
And you mentioned just now possible legislative change. Is that a real possibility in your mind?
I am far too modest to handicap what's going to happen in Congress. I'm by no means an insider in that world. I'm probably as much of an outsider as anyone. What I can say, and we go through this in some depth in the article, is that there are real legislative initiatives that appear to have some measure of bipartisan support to give the FTC new authority in this space that will replicate or replace what the agency did pre-AMG with 13B. Whether those will pass or not, I can't venture a guess. I certainly think it's a real possibility. To pick up on your language, it seems that there is definitely energy behind those initiatives at this point, and clearly the agency is putting its shoulder behind it. All of the commissioners at this point have expressed, both Democrat and Republican have expressed support for it. So I think there really is a real possibility that we're going to see legislative activity.
And what would the key issues be if there were to be new legislation?
So I think the first one is structural. Is the FTC merely being given back authority that mirrors its prior interpretation of 13B, or is it different than that in some way? And then I think the second set of questions are around the I'd call them corollary or framing issues. Will there be a statute of limitations? If so, what? Will the new legislation apply retroactively? And by that meaning to conduct that occurs before the legislation, or to cases that are pending when the legislation is passed, or investigations that are pending. And then finally, the standard of proof the agency must meet. And this sort of is arguably a question of whether they're merely replicating 13B or not. But Section 19, the other path that's in the law now for the FTC to obtain money in non-rule or non-order violation cases, has a higher burden of proof than what the FTC has to do to prove liability under 13B. The Section 5 of the FTC Act. So Section 19 requires that the conduct be dishonest or fraudulent from the perspective of a reasonable person. Exactly what those terms mean hasn't been very well developed in the court, but it's clear that it's higher than the basic Section 5 standard for liability. So whether Congress imposes that standard or something lower, as existed as a practical matter under the Commission's prior running of 13B, those are all the key hot button issues. And obviously there's other. I shouldn't say obviously. There are other, really a wide variety of proposals floating around from various quarters that touch on the FTC in other ways, privacy, changes to the antitrust laws. There are a number of things that could also be folded in as part of this effort. Totally unclear, at least to me, whether that'll happen or not. Obviously, those sorts of things involve complexity and could complicate the consensus building issues, but they're out there as well.
Okay, final question. In the title, you suggested that the AMG decision could be a watershed moment for the FTC. Do you really believe that? Will we really look back 5 years from now and talk about the case that way?
I think so. I really think so. As I said, we're going one of two ways. Either we're going to see new legislation, or we're going to see the FTC really change its playbook to take advantage of its current authority in much broader scale and scope. Either way, life looks different. I have no doubt in my mind the agency will remain a very effective, aggressive regulator under either path. But AMG will be looked at as a meaningful moment in the agency's history in either scenario. So exciting to get to see how it plays out over the coming weeks and months.
Wonderful. Rich, thank you again for your time today and for a very insightful article. We'd also like to thank the ABA and the ABA team behind the TNT series, Chris Cole and many others. Rich, thank you again for your time today. And once again, for everyone, the article name, The Watershed Moment, What Comes Next for the FTC in the Wake of AMG. Thank you again, everyone.
We hope you enjoyed this episode of Trust and Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.